Hello, I am Angelita Blackshear Dalton, Judge of Division 3 of the Davidson County General Sessions Court. Domestic violence is a pattern of abusive behavior in a relationship used to gain and maintain power and control over the abuser's partner. You will learn throughout this presentation that there are various forms of domestic and sexual abuse and the dynamics of domestic violence that impacts victims directly and our society as a whole. As such, there are entities and agencies in place that are designed not only to protect victims of domestic violence, but also to hold their abusers accountable for their actions. One aspect of protection and accountability through legislation is in the form of an order of protection. Pursuant to relevant chapters under Title 36 of the Tennessee Code, qualifying victims of domestic and sexual abuse may seek an order of protection in courts that have jurisdiction to grant such orders. The justice system and court proceedings can present themselves in a very complex manner for those who may not be familiar with the processes involved in the justice system. Knowing what pleadings to file, how to file, when to file, where to file, and the monetary expense associated with proceedings, and once proceedings have commenced, knowing what and how relevant rules of law, case law, and statutes are applied. Navigating your way through court and its proceedings can be difficult and intimidating for someone not trained in the legal profession. Adding to the complexity of understanding the justice system, the serious and sensitive nature of abusive behavior that leads a victim of domestic violence to the justice system can further compound the intimidation victims feel when dealing with the courts. Having the assistance of someone who is trained in the legal profession, more specifically a lawyer, who can help in navigating one's way through the court system is a major step in assuring people that they can have reasonable access to our court system.
Hello, my name is Darkenya Waller. I'm the Managing Attorney for the National Office of the Legal Aid Society. I'm here to speak with you about orders of protection and the basics of representing victims of domestic violence. I'm wearing a purple ribbon in honor of Domestic Violence Awareness Month, which the National Coalition Against Domestic Violence has designated in the month of October. We'll jump right into orders of protection and their purpose. Purposes of orders of protection. It's interesting that in our Tennessee Code annotated, our General Assembly in the state of Tennessee actually set out the purpose and the rationale behind orders of protection. They are to recognize the seriousness of domestic abuse as a crime, to assure that the law provides a victim of domestic abuse with enhanced protection from domestic abuse, and to recognize that in the past, law enforcement agencies have treated domestic abuse crimes differently than crimes resulting in the same hurt but occurring between strangers. If you can imagine the scenario where a stranger sexually assaults a woman, it is treated much differently by law enforcement and by the court systems generally than if that same crime had occurred between a husband and wife. The General Assembly laid out the intent that orders of protection and domestic assault and domestic abuse is handled differently. In that same code section of 36.3.618, it says that Tennessee's official response to domestic violence shall stress that enforcing the laws to protect the victims and to prevent further harm to the victim. Further, that the official response shall communicate the attitude that violent behavior is not excused or tolerated. This is powerful because it gives the direction that the General Assembly intended for courts as well as law enforcement to treat those who have been the perpetrators of domestic abuse or the victims thereof. So, who's covered under the order of protection statutes that are available to victims? Under TCA 36.3.601, It lays out that domestic abuse victims are defined as current or former spouses, current or former live-ins, current or former dating or sexual relationships, people who are related by blood, adoption, or marriage, or even former marriages are covered, as well as adults or minor children of someone in any of the above relationships. It should be kept in mind also that the order of protection covers adults, but also minors who find themselves in those situations. What's covered under the order of protection statutes? According to TCA 363602, domestic abuse, sexual assault, and stalking are covered. Specifically, domestic abuse. Inflicting or attempting to inflict physical injury by other than accidental means, including animals. That's to say that if there is an attempt or the inflicting of actual injury by something other than an accident to not only a person but an animal, a pet, a dog, those persons or entities are covered under the order of protection statute, as well as when a person is placed in fear of physical harm. Again, this applies to pets. If there is any physical resistance done, or if there is malicious damage to personal property. So, for example, a cell phone that may be destroyed, clothing that may be destroyed. These are also acts that are defined and then covered under orders of protection. Now that relates to domestic abuse, and as we talked about who's covered, it's domestic abuse as it relates to people in those personal relationships. But again, we have sexual assault and stalking. Sexual assault is defined as subjecting to or threatening with or placing in fear of any form of rape, regardless of the relationship. So sexual assault that has occurred from a stranger or person you do not know will still entitle you to an order of protection, as well as stalking, subjecting to, threatening with, or placing in fear of any form of the offense of stalking. Again, regardless of the relationship, you are covered under the order of protection statute. So, if you determine that it is appropriate in your circumstance to file for an order of protection, then you have to choose the correct venue within which to file. Our statutes at 363602 state that it is appropriate to file an order of protection in the county where the respondent resides, or the defendant, if you would, or the county where the domestic abuse, stalking, or sexual assault occurred. Now, if the respondent or defendant is not a resident of Tennessee, then at that time, the order of protection may be filed in the county where the petitioner or the victim lives. Upon the filing of an order of protection petition, the court may immediately issue what is called an ex parte order of protection. An ex parte order of protection, as the name implies, is given without notice to the opposing party. It is issued where, on an ex parte basis, there has been found to be probable cause, or that the defendant probably did do what is alleged in the petition. Once the petition is granted, the burden of proof goes higher at a second hearing, which actually, at the initial hearing, which then orders the actual order of protection. The burden of proof at that hearing is a preponderance of the evidence. In order to have an order of protection granted, it must be established that there is an immediate and present danger of abuse to the petitioner. Finally, a hearing on the ex parte order shall occur within 15 days of service on the respondent. This requirement is statutory. How long does the order of protection last? Initially, the order of protection lasts for up to 1 year. The court is required to give a definite amount of time for the order of protection to last. So it could be 3 months, 6 months, 9 months, up to 1 year. However, this can be renewed upon violations. If after an order of protection is granted, a defendant then violates the order of protection by doing a prohibited activity, then the victim may file a violation and move the court to extend that order of protection for 5 years, or for a second violation, up to 10 years. If the parties were married at the time, then when a divorce is filed, that order of protection automatically extends for the duration of the divorce. There are no fees to the petitioner, no costs to the petitioner for the filing of an order of protection. This is pursuant to statute 363617. A petitioner shall not be charged the cost of filing an order of protection, even if the order of protection is later dismissed. That fee still cannot be charged to the petitioner unless there are very specific grounds that are found by the court to warrant it being assessed to the petitioner. Specifically, the court must find that the petitioner is not a domestic abuse victim, stalking victim, or sexual assault victim. Secondly, the court must find that the petitioner knew that the allegation of domestic abuse, stalking, or sexual assault was false at the time the petition was filed. If neither of these findings are made, then costs cannot be assessed to the petitioner. An order of protection may be modified upon motion by either party by showing a change in circumstance. So, for example, if there is a violation of the order of protection, it may be extended. Or if there are terms that were ordered within the order of protection that are no longer working, or there is a change in circumstance, the court can modify it at that time. Full faith and credit of the order of protection. Orders of protection are granted full faith and credit across state lines. This provision was first found in the Violence Against Women Act of 1994. In order for there to be full faith and credit, meaning that it can be enforced in other states, there must be a finding of domestic violence to establish subject matter jurisdiction, even if it is a consent order. So if in your county a order of protection is agreed to by the parties, it is not enough for the court to grant it based on that agreement. There still must be a finding of domestic violence in order for that underlying order to then have enforceability in other states. OPs are enforceable across state lines only if there is subject matter jurisdiction. Mutual orders of protection, unless it has been petitioned for, are not enforceable across state lines. That is to say, if one party files for an order of protection and the court chooses to then grant a second order of protection to the alleged abuser, then that order of protection becomes unenforceable across state lines because it has not been initially petitioned for. There are many resources available to you to find out more information about orders of protection, one being the Legal Aid Society website, the Tennessee Coalition Against Domestic Violence website, or the ABA website and Women's Law website. Please feel free to refer to any of those to find additional information about orders of protection.
Hello, I'm Deborah House, and I'm an Associate Director at Legal Aid of East Tennessee. I'm going to talk today about the forms used in order protection cases. Much of what I talk about will follow the statutory requirements that Darkenia talked about earlier. The first form we're going to talk about today is the petition for an order of protection. And before we talk about the forms, let me tell you where you can find the forms. These forms are promulgated by our Office of the Administrative Office of the Courts. And TCA 363604 dictates that the Administrative Office of the Court shall promulgate forms for all to use in petitioning for an order of protection. These forms can be found on the AOC's website. The Administrative Office of the Courts has promulgated uniform forms for use across Tennessee. Some counties, however, and local judges choose to use different forms. So these are the forms you will most likely see when you are representing a victim of an order of protection. However, in some courts the forms may look different, although they will contain substantially the same type of information. If at all possible, it's important to help your client complete the forms, particularly the petition. The petition contains very important information the court will use to determine whether or not the victim is eligible for an ex parte order of protection and what subsequent relief he or she may receive. However, in most circumstances, your client will come to you with these forms, the petition at least, already completed and filed with the court. At which point, in reviewing the petition, if you do find that there are deficiencies in the petition, you may choose to advise your client to file an amended petition. And we'll talk about that later, how to go about doing that. The first thing I would like to mention in the petition is you see a section for petitioner's children on the very first page. It's important to list all children of the relationship who need protection and also other children who may be living in the home with the respondent and you, even if the children are not of the relationship. Now, different courts may handle how they deal with children in an order of protection in different ways. Some courts will take the position that these children are under the order of protection and there may be no contact communication. Other courts may take the position that these children are protected from abuse or threats but are not limited in terms of contact. It's also important to know at this point whether or not there is another custody order or other court orders related to the children, and that will also be discussed further on in the petition. A note about unemancipated minors. Minors cannot petition for an order of protection on their own. Only an adult or a DCS caseworker can file a petition on behalf of an unemancipated minor. And if the respondent is a minor, service must be perfected upon the minor's parents as well as the minor. The section in the middle of this form that is in a box that says respondent's information is very important to fill out for a couple of reasons. First of all, this helps law enforcement in terms of finding the respondent and also serving the respondent with the appropriate papers. Also, this information is uniform across all contiguous states to Tennessee, so if there is an interstate action such as Darkenia spoke about earlier, other states' law enforcement will be able to recognize immediately this information. It's on the front page of all petitions in all contiguous states to Tennessee. Towards the bottom of the first page, you'll see relationships. And Darkenia has already talked about the requisite relationships to qualify for an order of protection. And note the bottom two boxes do involve stalking and sexual assault. And as Darkenia talked about, there's no relationship requirement for a victim of stalking or sexual assault to fall within the statute. On the second page of the petition, you will find more information about the children and a section about other courts who have made orders about the children. And this is important to help our courts know whether or not they do in fact have jurisdiction to address issues concerning any minor children. The bottom box on the second page is probably the most important section of the petition. This is where the victim will describe the abuse that gives rise to his or her need for an order of protection. It is important that this section be very specific and detail the most recent incident of abuse as well as prior incidents of abuse. As Darkenya noted, the standard for granting an ex parte order of protection is immediate and present danger of abuse to the petitioner. This shall constitute good cause. So that's what the court is looking for in this box when they read the petition, an immediate and present danger. The following page of the order of protection petition, page 3, talks about relief, what we would normally look at as a prayer for relief in a pleading or a complaint. And you will notice some of the boxes are pre-checked. For instance, the box at the bottom of the page, box number 15. There are some prayers that are mandatory in all orders of protection, particularly concerning firearms. It's important that as the victim is filling out the petition that he or she understand the various types of relief that they can ask for and that they think ahead onto what they ultimately will need to achieve safety and permanency in their lives. You notice the first two boxes mention no contact and stay away. One may wonder what the difference is between those two. No contact means no contact at all, period. Phone, text, email, at all. Stay away means you must physically stay away, but there can still be other contact between the parties. Some courts will call this a social contact, and we'll talk more about that later when we review the final order. And it's, again, important for the victim to think through exactly what he or she needs to secure his or her safety and the safety of the children. It's also important in looking at this list of potential relief that the petitioner think about the children and what may be needed for the children. And I will note here, and we will talk a little bit later about the fact that some courts may choose not to address issues concerning the children. Certainly the victim may ask for custody and child support and other relief. It's within the court's discretion whether or not to grant that relief. And you will notice on the following page the box concerning costs, fees, and litigation. Number 17 is also pre-checked. As Darkenya mentioned earlier, the assessment of costs when the order of protection is completed is generally not within the discretion of the court, with an exception that, again, we will talk about later. The next one that we'll look at is the temporary or ex parte order of protection. This is the order that the court may issue after reviewing the petition, the allegations contained in the petition, as well as perhaps speaking with the victim. Some judges and magistrates will actually bring the victim into the office or an open court and speak with the victim and get their version of the facts. Other judges or magistrates may choose to just review the written petition. Again, that is one of the reasons why it is so very important that the allegations be very specific and detailed. If the court finds there is an immediate and present danger, the court may issue this temporary order of protection. This order of protection is valid as soon as it is signed. However, it must be served upon the respondent. Until the respondent is either served or receives actual notice of the ex parte, it is not enforceable. Much of the information at the top of the ex parte is the same as the petition, and you'll see this again in the final order of protection. And now again at the bottom of this page, page 1 of 2, the ex parte, you'll see that some of the boxes are again pre-checked, obviously preventing abuse, threats, and so forth against the petitioner and the petitioner's children. The bottom box on page 1 is not checked. This is where the victim or the judge would determine whether or not there's sufficient cause for a no contact order, a stay away order, or both. And you'll see at the top of the next page, the first box again talks about contact and staying away. At the ex parte stage, the court may order that the respondent leave the residence, may grant temporary use of the residence to the petitioner. Other than prohibiting abuse, threats, and so on, and use of the residence, the court is really without power to do anything else at the ex parte stage. And when we look at the final order, we'll discuss that a bit more, the other relief that's available only after a hearing. The box in the middle of the page is very important. It tells the victim and the respondent when they're supposed to go to court. The respondent may choose not to come to court, in which case, in most situations, the court would grant what some courts call a proof order of protection, or we may know as an order by default if the respondent's been properly served. It's very important that the victim do come to court. If the victim is not there to prove up his or her case, in all likelihood the court will dismiss the petition. The ex parte contains various warnings to the respondent in terms of guns and violation and so forth. As Darkenia mentioned in her presentation, there must be a hearing within 15 days after the ex parte is served. So the victim needs to be aware of that. If for some reason in the county in which you are practicing, for instance, the judge may ride circuit and you may only have a judge once every 3 or 4 weeks. That's something to be aware of, and certainly the court clerk should work with you to accommodate that situation to make sure hearings are held in a timely manner. The following form is actually the order, the court order that the judge signs that becomes the permanent order of protection. And again, there's a lot of meat in this order, and it's very important this order be filled out completely and accurately. Things that are not in this order obviously cannot be enforced later. So this goes directly to the petitioner's safety as he or she moves forward. Notice at the top of the order there's a box for amended order. And we'll talk in a minute about what that means. If this is an amended order or a subsequent order, not the original, it is important that that box be checked so the court, law enforcement, and the respondent know that this is a second or subsequent order. If that box isn't checked and this order supersedes a prior order, it could cause problems in terms of enforceability. Towards the bottom of this page, page 1, you will see findings about abuse. Darkenia already addressed the importance of having findings in terms of full faith and credit. Findings are also very important in terms of the Federal Violence Against Women Act and the gun provisions. There have to be certain findings made before the gun prohibitions come into effect. And you will notice to the right there's a picture of a gun and warnings. This is to let the court, law enforcement, and others know that there have been firearms involved in this case and to use extra caution and diligence in dealing with these types of cases because firearms are implicated. Some courts will produce this order after the hearing. Several courts in which I practice, the judge has a court clerk in the courtroom. They actually produce the order and serve the order upon both parties at the time of the hearing. However, in most courts, it will be the responsibility of the lawyer to complete this order and have both parties sign it. So again, it is very important that the order be thorough and complete. There's a section at the top of page 2 concerning findings about the minor child. This goes to jurisdiction, and under the Uniform Child Custody Jurisdiction Act, it may be necessary for the victim to go to the home state of the child to petition for relief or protection for the child, and the court here may only be able to grant temporary short-term protection. So that's something to be aware of. There's a section about findings concerning firearms. Again, this is vitally important if there are firearms, if the respondent owns or possesses firearms and an order of protection is granted, the respondent must dispossess him or herself of those firearms. And there's a form for use that we will discuss in a moment concerning firearms. You'll see towards the middle of the page the court orders the respondent to, and again we have pre-check boxes, things the respondent can never do: stalk, threaten, abuse the petitioner or the minor children. The rest of the relief in the order is within the discretion of the court. 363606 will list, Tennessee Code will list the forms of relief available to the petitioner. And you will notice in reading that statute that the court is not limited to those items listed within the statute. The court may go on that and order additional relief as the court deems necessary and appropriate. Also, the court is not bound to order or address all the issues listed in 363606. The next page will deal with children, child support, and so on and so forth. You may find that your courts are not willing to address particularly child support. Although they may grant temporary custody of children, child support is also often a complicated and difficult issue to address, particularly with our child support guidelines and the requirement of mandatory child support worksheets. Quite often, orders of protection courts are not equipped to deal with the worksheets at that point in time unless a lawyer comes prepared with the computer program on a computer and a way to generate those worksheets. If you are setting child support and you are not following the guidelines either at the direction of the court or convenience, as the case may be, it is important to note that the order is made without a presumption of correctness. This should allow the petitioner then to go and seek an appropriate child support order based on the income of both parties, either through the local child support enforcement office or on their own. And my concern would be if you do not list without presumption of correctness, the child support court may consider this res judicata and not take another look at the child support issue. Towards the bottom of the page, you will see a box for support of the petitioner. The court may order support for the petitioner only if the parties are married. If the parties are married, then it is in the form of alimony pursuant to the alimony statute. The bottom portion of this page addresses issues concerning property, real property, who is to have possession, and arrangements for the respondent to retrieve personal property from a shared residence. It's important to know local law enforcement policies and procedures in terms of accompanying somebody to a home to retrieve their personal property. Many law enforcement agencies will have a policy of only going to supervise retrieval of property during daylight normal business hours, not on nights, not on weekends. So it's important to work with local law enforcement. If you cannot or choose not to have law enforcement present, it is always important to have a neutral third party available to supervise any exchange. It's also a good idea for the petitioner not to be present, and also to make a list of any items that are taken out of the home in case there is any question or controversy about that in the future. Page 4, again, orders concerning firearms. You will notice all of those boxes are pre-checked. It is not optional within the court after an order of protection is granted to allow the respondent to maintain his or her firearms. It is mandatory that they be dispossessed within 48 hours of the order being granted. The final important section on this page is court costs, fees, and litigation taxes. And Darkenia has already spoken about this in detail. If the order of protection is granted, the respondent shall be assessed with court costs pursuant to 36-3-617. Also, of interest to attorneys taking cases pro bono, the court shall assess attorney's fees if the order of protection is made permanent. So certainly you may ask the court to assess attorney's fees, and there is appellate law that the court shall award attorneys fees. It is not optional for attorney's fees to be granted. The box below where it talks about this order taking effect immediately talks about a 1, 5, and 10-year order of protection, and I refer you back to Darkenia's presentation of the statutory sections concerning when an order of protection may be extended and for how long and based upon violations. The next form we're going to talk about briefly is used in criminal court. And this is an order granting bond in a criminal situation. When somebody is arrested for a domestic violence crime, there are certain bond conditions that must be met, and this form must be filled out and completed before a defendant or respondent can be released on bond. Many of these conditions you will see are very similar to what you see in an order of protection. Some respondents may argue and state that it is not necessary to have an order of protection because there are bond conditions in place. However, bond conditions can be removed if the case is tried and the bond conditions are released. The victim would no longer have protection, whereas the actual order of protection can remain in effect for up to a year or longer. So it is very important that the victim not rely solely on the bond conditions, but also seek the order of protection to which he or she may be entitled. The next form is the firearms declaration. I mentioned earlier that if an order of protection is granted, the respondent must dispossess him or herself of all firearms within 48 hours. This is a mandatory form that must be filled out and filed with the court clerk immediately upon the respondent turning over the firearms to a party permitted under the statute. And I will refer you to the statute for specific details about when this is used and the specifics of how and when the respondent must dispossess themselves of their firearms. I would note that in some courts in Tennessee, judges may have a different interpretation of the firearms requirements as well as the requirements on underneath the Federal Violence Against Women Act. You may want to review that statute in detail if you do have firearms at issue before advising your client about how this may work. We've talked about the petition. We've talked about the order. There are a couple of things that may happen after the hearing that involve different forms. First of all is the dismissal of an order of protection. There's a separate form that the court has promulgated in those situations. A petition for an order of protection can be dismissed upon the request of the petitioner, if the petitioner fails to show up for the court hearing, or after a hearing if the court finds that the petitioner has not proven his or her case by a preponderance of the evidence. And if the court does choose to dismiss an order of protection for any of these reasons, this form must be completed. You will notice towards the bottom of the form, the court hereby finds, and there are several options that I just discussed. Towards the bottom is the important concern about costs. And Darkenia has already spoken in detail about the two-part analysis that the court must review in order to assess any court costs against a petitioner. And these two factors are set forth in detail in box 1, and at the very top of the next page is the second part of that analysis. It should be a rare situation where the court assesses court costs against a petitioner of an order of protection. Given the two-part analysis and the detail and the necessity of the findings, it would be very rare for a court to find that a petitioner should be charged with court costs in these types of situations. The final form that we're going to talk about is a motion to modify or extend an order of protection. As we have discussed earlier, orders of protection can be granted for up to 1 year and can be renewed for additional 1-year periods of time if the petitioner is still in a situation of fear and danger where the order of protection is justified. TCA 363605B allows these continuations for additional 1-year periods upon notice and showing of cause. This form would provide the notice to the respondent that the petitioner is seeking to extend the order of protection for additional 1-year period of time. This form is also used in the situation where there has been a violation and the respondent is, or the order of protection against the respondent is going to be for a period of 5 years, or if there are second and subsequent violations, up to 10 years. And you'll notice at the top of the next page there are boxes for the 5-year and the 10-year situation. Also, other relief requested. The petitioner may ask for additional relief at this point in time. Another scenario where this may be used is the petitioner may wish to modify her order of protection rather than simply extend it. And the situation I have seen is where there is currently a social contact order and the petitioner feels that he or she then needs a no contact order of protection because events have escalated, there have been ongoing problems, or vice versa. Sometimes a situation will arise concerning children that was not anticipated, that was addressed in the initial order, and it's necessary to modify the order. TCA 363305 subsection D does allow for modification, again, upon notice and hearing. This form also addresses a situation where it is very near the expiration time for the order of protection and the petitioner has petitioned to extend. However, that hearing cannot be held before the expiration of the existing order, in which situation the court may, on an ex parte basis through this order, extend just until the hearing. It's very important that petitioners think through, if the 1 year is coming up, when they need to be petitioning for additional relief and plan timing at least a month in advance so that there's time for petition, for service upon the respondent, and time for hearing. And finally, this form will have a notice of hearing to the respondent. Again, these forms are all available on the Administrative Office of the Court's website and are available for use. You may find different forms or additional forms in the county in which you practice. It's always important to know your local court clerks in your practice to determine what is used and acceptable in the courts in which you practice.
Now that we've discussed some of the basics of orders of protection and abuses against victims, we wanted to get into some of the tips that we've learned over the years in pursuing these cases as it relates to the witnesses, preparing for the hearing itself, and then the trial itself. Specifically, in your materials, you have information that speaks to preparing the witness, and I'd certainly encourage you to review that and certainly discuss it with the witness as you prepare for your hearing. Just things such as exactly what happened and what it is that you'll be talking about. I'm always amazed how many people don't review the actual petition itself, because so many things have happened that they feel they know what to say, but oftentimes courts will not want you to speak on anything other than what's in the petition itself. So it's very important to review the actual petition with the witness and to be sure that they know what they're preparing to talk about. Of course, encouraging them not to tell any untruths, to be very truthful, because in order of protection hearings, and this probably is the case with you, the client's credibility is almost the most important thing, because no one's there, no one saw it, and so all they have to go on is their word. So at all costs, being truthful so that they establish the credibility that you want them to have.
And one of my tips is helping the client understand how the court determines credibility and how demeanor influences the judge's decision. If your client is sitting on the witness stand and is bawling or is particularly angry, that is not going to leave a good impression with the judge.
Absolutely. Additionally, discussing with the client what the client wants. Oftentimes in the petition that they file, they'll ask for support. They will ask for visitation and custody to be established, but then not know exactly what it is that they want. The more articulate they are about being able to explain to the court specifically what it is that they want, it enables the judge to actually give them that relief.
And I think it certainly goes without saying to know your judge and know what relief your judge is willing to grant. Some judges, as we talked about earlier, will not be willing to deal with the custody and the child support issues. And also I think it's important to have your client think through various alternatives that he or she may want, so they're prepared in case they are seeking, for instance, full custody and supervised visitation. That may not happen, and what the alternatives are in their mind.
I also encourage you sitting down and trying to find out all the skeletons before you get to the hearing. I often will pull the criminal background of my clients to the extent that I can to make sure I know what their issues are and are able to combat those before they come up in trial. Finally, I suppose just being sure that you manage your client's expectations and in terms of what's possible. Oftentimes there's the demand for the supervised visitation, and while the abuser may have been a horrible spouse to you, they may have been a great parent to the child. And so just in terms of managing the expectations of what may actually occur before you get to the hearing. Additionally, tips in terms of just preparing for the hearing itself. As soon as I am in contact with my client, if there's any bruising associated with the abuse that may have occurred, encouraging them to take pictures and to do it immediately. Telling them to, if there are danger, if a danger occurred that actually caused physical harm for which a hospital visit may be needed, go ahead and advise them to do that in preparation for the hearing.
And certainly look at law enforcement, police reports, and whether or not police officers are necessary. There's only a 15-day turnaround time between the service and the hearing, which often is not time to get subpoenas out. So be thinking about what subpoenas you need and getting them out timely. And also be aware if you're needing phone records or other types of documents such as that, it's often impossible to get those within that 15-day window.
using the affidavit of the custodian of records to the extent you can remember to do that, such that the documents you get, if they're not by subpoena, are admissible. Also, in terms of those courts that do allow support to be awarded, bringing whatever financial information that you could possibly get your hands on that would help you establish your clients as well as the opposing parties' income in order to get that support put in place the first time without having to do a second motion to modify to have that adopted.
And always, I think it's important to review the rules of evidence in advance, because there are certain rules that you will use over and over again in orders of protection, such as the business records exception, impeachment of witnesses, and so on.
Mm-hmm. In terms of preparing for the trial itself, perhaps one of my biggest requests, if not a tip, is that you don't, in a divorce hearing, negotiate away the order of protection. A lot of times when you take it from the order of protection state to the divorce state, it's always a desire to kind of get the order of protection out of the way, or to replace it with a restraining order or mutual restraining orders. Well, the fact of the matter is they are not the same thing. A restraining order will not have the police at your house immediately when a violation occurs. It requires a separate action where you return to court to enforce that restraining order. And so hold on to that order of protection. It is possible to get what you want without having to give that away.
And think through and talk with your client about what his or her bottom line is, because often you'll be negotiating your orders of protection. Mm-hmm. And I think that varies by county. Where I practice, we negotiate quite a few of our orders of protection, and it's easy to anticipate what the other side is going to ask for and argue, and think through what your client's best alternative and worst alternative to litigation is, mm-hmm. and make sure they understand that and you know that in your mind.
Also, in terms of presenting your case, I always encourage you to make a comprehensive opening statement. If you can get out as much of the facts as you can as the attorney, it kind of helps set the stage for what your client will then testify about. So in making a comprehensive opening statement that really lays it out for the judge, you do your client a great service.
Another tip that we use in my office is to always not only bring the statute with you, but we prepare orders of protection notebooks for all of our advocates that has the statute, relevant case law, relevant criminal statutes, relevant rules of evidence. It's a complex statutory scheme, and it's very helpful often in negotiating and certainly in closing argument with the court to be able to cite the law and the specifics in the statute, to have that right there at your fingertips.
Also, getting to the point quickly. A lot of courts do multiple orders of protection, and it's one of the type cases that they try and get through. And with that being the case, you really want to get to the point fast. If there's physical abuse, get to it immediately. If there's someone who has been harmed, get to that point immediately and talk about it first. It kind of grabs the attention of the fact finder and allows them to make the decision that you want.
And make sure your client understands, although he or she may have 10 or 15 potential witnesses and they come to court bringing everybody in the family and beyond, the court is not going to hear those 10 or 15 witnesses. In Knox County, for instance, there's a standard rule that the court will hear the victim, the parties, and one witness. If it was going to require more than that, a special setting is required.
I also encourage you to review your petition before you close out your proof. Make sure that you've gone through that petition to cover everything that the client or victim has asked for. You will have to address those things. If there's protection for the child that's needed, be sure that you're addressing that in the hearing, because if there's no proof about the abuse towards the child, then it may not be granted as it relates to the child.
And also make sure you know whether or not there are criminal charges pending against the respondent. Many times there will be, and the respondent, when they are in court, will invoke their Fifth Amendment right to not testify, which can potentially throw a wrench in your case, may cause the other side to seek a continuance. Some courts will continue cases indefinitely until the criminal charges are resolved. Some will not, so be prepared for that.
And also, going back to the full faith and credit that we talked about earlier, it is required that there are findings. And so even if you, outside of the courtroom, agree to the order of protection or agree to certain terms, be prepared that the court still needs to make that finding such that it does have the applicability across state lines.
I guess one of the final tips I would have for the private buyers, don't forget to ask for your attorney's fees. The law has changed recently to allow that, or at least for legal aid attorneys, and I know that my staff, although they can seek attorney's fees, they routinely forget because they're so caught up in the trial and the findings and so forth.
So it's available, so we suggest that you get it. Well, I guess that's all the tips I have, and hopefully they'll do a good job out there for their clients.
Thank you.
A significant result of providing resources that allows parties to have reasonable access to our court system is allowing the courts to fairly and impartially administer justice. When parties who otherwise may not understand the dynamics of court proceedings have legal representation, it allows the judges to fairly weigh all relevant facts and evidence, taking into consideration applicable rules of law, case law, statutes, and arrive at a fair decision. It is helpful when parties understand the role of the court, the boundaries within which judges must operate, and what is expected of the parties during court proceedings. These are factors that can be achieved when parties have representation. For an example, parties often come into a trial attempting to testify to facts not contained within a petition or may otherwise be irrelevant to the case. Parties may fail to present evidence or testimony that will be helpful to the court in arriving at a decision, or parties who are not qualified under the statute as a domestic abuse victim may attempt to seek an order of protection. Many of these issues may be cured with appropriate representation, thereby allowing the court to focus its attention on rendering a fair decision that will protect victims of abuse and hold abusers accountable.